Hello, everyone. Welcome to Court with Krissy. This is not the typical case that I would share. It's extremely sad and very serious, but both sides put forth excellent arguments. Please watch to the end and leave a comment with your reaction to the judge's sentencing. Court with Krissy is now in session.
All right, now if everybody can hear me, we will go on the record in the matter 23 CF 160, State of Wisconsin versus Ashton Heyer. The state appears through Assistant District Attorney Kevin Schmidt in person. Mr. Heyer appears in person in custody with counsel Catherine Chevalier. We're set here today in this matter for the sentencing portion of this case. Mr. Heyer pled guilty to one count of possession of a firearm by an adjudicated delinquent of a felony and one count of homicide by negligent handling of a dangerous weapon. The court did not order a pre-sentence investigation report. We do have victim appearing by Zoom capability. TP, who does wish to provide a statement to the court here today, a victim impact statement. TP, you are free to provide your statement.
You can hear me?
Yes, I can.
Okay. Well, it's like a page and a half, and it's just from my point of view of things.
Miss TP, I'm going to ask you to please, if you are reading a statement, read it slowly and enunciate your words so that everybody, especially the court reporter, can hear it, okay?
Okay. Ashton and Aaron were a lot like what real brothers would look like, talk like, and fight like. Either way, they always treated each other a lot like brothers. I've even laughed often when they would tease each other and act all tough, standing up to each other, chest to chest, talking shit to one another, and saying they're going to do this and that to each other. At the time, I thought either one could never hurt someone, at least in the time frame I'd been with Aaron. I haven't seen any physical actions come from Aaron towards anyone. He may get loud and a little aggressive with his words, but he never had any physical contact with anyone unless someone struck him first. In all reality, when it comes down to it, Aaron loved his little brother. Aaron would strongly grow attachments to people who would stay in his life momentarily or whoever was in for the long haul. He didn't have much family growing up. His aunts and uncles were all far away. He grew up very close to his dad, considering he was Mark's only child. His birth mother gave him up and was never in the picture based on what I was told. Some people had opinions about Aaron due to his dry and sometimes derogative sense of humor. But that's something I admired in him. He was genuine and authentic and never swayed away from what he believed in or let anyone walk over him. I thought he was fearless and unique, never scared of anything or anyone. I guess his pride is what led him to his death. After Ashton had shot the first warning shot, he still wasn't scared. He just kept walking, probably teasing the theory of if Ashton would ever hurt him. Well, his testing theory failed. I don't know what was going through their minds that night, but that was the night my life changed forever. Aaron's misjudgment and Ashton's fury is what cost Aaron his life. As for Ashton, his life was off and on being a problem child, already having a violent history at such a young age, from my knowledge, and knowing Ashton's mom and sister. Not going into detail, long story. Yet again, I've known these details and statements through a past relationship. From my understanding, him and his big sister grew up not having the support they needed, which made his sister and him act out as young teenagers. I know that for a fact. At the time, Ashton disliked his mom so much at the time he begged to move in and live with stepdad Mark. I too was living in the camper outside of Mark's, and I eventually moved to James Way with Aaron. Aaron and Ashton would talk amongst themselves and would hear certain things and and merge myself into their conversation. Oh my God, seriously, some of the things I couldn't believe what I heard come out of their mouths about living their lives out as teenagers. It appalled me to hear so much about a bunch of random bullshit of all different things. Aaron and Ashton grew up a lot in the same ways. They had similar stories about each other, which sounded pretty rough around the edges, but sounded as if they ran their own lives, doing whatever they pleased, not caring about the circumstances, which to me in every way a lot to do with how they both acted as adults. Aaron and I met when I was 10 and he was 11. We knew each other from a young age up to our teen years. We had some of the most awesome summers. We would play together and he'd often come to my house. We would play Barbies, cars, and games, go swimming, etc. Growing older together, remaining friends, having special moments. Aaron was my first kiss, and later on told me he would do anything for me, and that he loved me no matter where I went, and he would try to find me. Later that summer, we separated, moving and transferring to different schools, not seeing each other for what seemed like forever. Way later, fall of 2023, he found me again. Sounds like a fairy tale, right? Well, we were together from that point on, and our relationship grew just like any other couple. Aaron and I were to be wed October 31st of last year, and we could have had a whole life together. We wanted so much out of life together. I couldn't believe how much he was changing into the person he wanted to be. I was just head over heels in love with Aaron. I've been through hell and back with that guy before all this happened. He would even tell me, his adopted mom, that he loves me so much and that he would do anything to better himself and do things that Dad would be proud of him for. Oh my God, I can't even begin on where to start on how much he loves Dad. He would have tried his hardest to make things happen, or things just to make Dad happy. He felt he needed to protect Dad from everyone and anything. Didn't want to go anywhere. He would even go to his work just to make sure Dad was okay. I don't know what he was so over worried about, but you couldn't tell him no when it came to Dad. It was like his life mission to protect Dad at all costs. No matter the circumstances, he would not care. But no matter what, he'd always be there. Aaron did care about certain people, but it was hard to tell on most days. He was a brute, but I loved him, still love him, wishing he was still here. I don't think anyone, but maybe Dad, realizes the pain Ashton has put a strain on my heart medically from anxiety and stress. My heart is slightly swollen from everything I've gone through since that day. I've had so many therapy appointments. I lost count. I have trauma classes just to deal with what goes through my mind every day. Over and over, that night plays in my head like a favorite song on replay. I'm hoping over time things get better. But as right now, I'm so scared of loud noises and too much commotion, I start to shake and cry automatically. And it doesn't go away for some bit of time. But my automatic reaction to sudden loud noises, I cover my ears and most often duck down because I'm in panic mode, scared and trying to comfort myself. Often when this happens, it's like I'm there reliving that moment over and over with what I saw and went through that night. I wish I could unsee what I've seen, but I can't. Seeing your loved one die right in front of you changes you in ways I wouldn't wish on anyone to ever go through. Sometimes you wonder if it's real or not. I gotta reassure myself some days until I look at my bedside where the most beautiful gold urn I got from my love rests, reminding me every day that he's gone. When I often think of him and the time we've shared, reminded me. Okay, I'm sorry. I often think of him and the time we've shared. It hits me hard to the point where I'm weeping and gasping for air, especially times like this, because my love is not getting any justice with what charges his shooter is getting sentenced to today. It's damn sad and painful to know that with all the statements and interviews that this is the outcome. I don't understand how someone could get away with killing another human being. Aaron did not deserve to get shot and killed, especially over a chainsaw. Future reference was something so small and petty he killed someone for. And you're gonna just trust putting him back on this street so early? Or until he gets mad about something else and someone else? How long till he kills and hurts someone else? If it had been an accident, his gunshot would have been different and possibly still be here. But with no actual reason, took a gunshot through the heart, all because Ashton wanted to throw a fit over a simple chainsaw. And Aaron that shot through the heart, well, because Ashton wanted to. I'm sorry. Ashton shot Aaron because he thought Aaron was a fucking psycho. Well, look in the mirror, kid. Who's the psycho now? If Ashton is not getting what he should be getting, then I request as a victim to see him get the max on both penalties. If he is not being charged with murder, then what else is the state of Wisconsin letting people get away with? In all my life and living here now, I finally moved away from the awful place because I think Burnett County, they failed to serve justice. I'm done, Rue.
Thank you, TP.
Mr.
Mr. Schmidt, I'm going to turn to the state for argument and sentencing recommendation, please.
Thank you, Your Honor. We reached an agreement in this case for the defendant to plead to a negligent handling of a dangerous weapon causing death and felon in possession of firearm. Person adjudicated delinquent with a felony possessing a firearm. It's a joint agreement of 7 and 10 out, encompassing a total sentence of 17 years bifurcated prison sentence with 7 years initial confinement, 10 years extended supervision. So it is a max sentence on the homicide count, consecutive to 2 and 5 out on the felon in possession of firearm count. I'm going to structure my argument a little differently than normal because the driving factors to this resolution are largely historical in terms of Ashton's past and factual as it relates to the offense. Certain personal factors about Ashton are highly relevant to the imposition of the sentence. This agreement comes from the facts based on what we know from investigation by law enforcement and review of Ashton's past files. And the fact that it's impossible to know what's going on in someone's head when they commit an offense. Wisconsin structures its homicide statute such that when you kill someone, what level offense it is, whether it's an intentional or a second degree intentional or reckless or a negligent, is all dependent on what's going on in the person's mind. We were unable to find evidence of a premeditated plan, and the circumstances leading up to the shooting belie an account where Ashton did a Columbo-esque cold-blooded murder. It wasn't that, it was a hot-blooded one. As to whether reckless or negligent homicide fitted better, it was all about what risk Ashton was aware of at the time as of to what he was doing. As to the elements of self-defense, which has been a big part of the filing, there were some factors that fell both ways in the equation. As a result, the state believes a max sentence on the homicide that is a fully aggravated negligent homicide with a high felon in possession of firearm conviction consecutive is appropriate. So when I talk about the historical stuff, when I talk about Ashton's personal factors, we have to start back when Ashton was 5 or 6 years old. This is in line with one of the written statements submitted to the court, I believe by Ashton's sister. When Ashton was 5 or 6 years old, he was victimized as a child. He was victimized in a very profound way. It happened multiple times and was a very severe victimization by a neighbor who was trusted to babysit him. The delinquency filed against that neighbor was back in 2012. According to Katrina Heyer back then, even at that age, at 6 years old, Ashton had indicators that she believed of ADHD and autism or Asperger's spectrum. Those things wouldn't be diagnosed later. The ADHD would, but the autism, rather than being diagnosed by a doctor later, would come out as mild retardation. Katrina at that time was having trouble getting Ashton set up for services because of insurance coverage and because of having to move so much with like her job. It took about 2 years after that incident, after that trauma as a child, when Ashton began acting out. In 2014, our office received 3 delinquency referrals in regards to Ashton for battery, for DC, for crime damage. Our office didn't file anything back then on those because Katrina has always been an active person at trying to deal with Ashton's issues, at trying to get him treatment on her own. She's always been a top-notch mother who's done her best to try to address Ashton's needs, and Ashton has a lot of needs. It wasn't until 2017 that petitions started to be filed. Between 2016 and the substantial battery a couple years ago, there had been 6 delinquencies or JIPs, parent unable to control, filed regarding Ashton. All very similar behavior, batteries, DCs, crim damages to family, to caseworkers. Ashton has done a wide gambit of treatments over the past 10 years, either through Katrina's efforts or through the DISP orders here and in St. Croix County. He's done day treatments. He's done a lot of therapeutic things. Various diagnoses he's received over that period of time have been ADHD, severe learning disabilities, mild retardation. Anxiety is something that comes up a lot. In therapeutic settings, he's frequently described as being physically intimidating and aggressive towards peers and staff. That's been an issue going back to him being a young child. Even through the most recent delinquency petition and DISP order we've had here in this county, the last one he was on before aging out, he was still doing treatment to address the trauma. He had individual therapy he was doing for that. He's never really addressed that trauma from his childhood, and he's continued to have these same behaviors going into adulthood. Anxiety, attention problems, behavior problems, and what the doctors describe as alienation/perception problems. That he perceives situations incorrectly, and it results in him getting alienated either by being physically aggressive with others or just alienating himself because the anxiety of the situation. That is, the doctors themselves have diagnosed, going back to him being a young child, he has flawed perceptions of situations. These behaviors continued through his childhood, through his adolescence. He's been on DISP orders, getting this assistance now for most of his life. As he's gotten older, his mother, Katrina Heyer, has been reporting increasing difficulty dealing with him as he gets bigger and stronger. When you're a child, it's easier to discipline a small child, but when he gets big enough to fight back, it becomes a problem. In the last PERM plan submitted to the court, it references Katrina saying to caseworkers that she's afraid of Ashton in her own home, that she walks on eggshells because something simple can set him off. That's around that time that the substantial battery in 2022 happened. According to Ashton and his co-defendant in the substantial battery, another child of similar age, they were offered alcohol by an older adult, which they accepted. He touched one of their butts at some point and they fought back physically. They were able to knock him onto the ground and then beat him onto the ground way in excess of what's allowable by law, which is why he entered a plea in it in the end, causing $13,000 and some dollars in medical bills to the victim. That was a case where duty to retreat and excessive use of force were really relevant, why it wasn't self-defense, why it was poor judgment on Ashton and his co-defendant's part, what they did. Because that once the person's on the ground and his level of intoxication described by law enforcement were such that he wasn't really a threat when Ashton and his co-defendant continued to beat him. During the course of that dispositional order, Ashton went to JDC in Eau Claire and eventually participated in the 180 program. It's where we have another escalating behavior. There's a worker at the JDC who Ashton believes is unfair and is just generally mean, not just to him, to the other kids. We know this from the letter he wrote to the court and from what he said at the time. He assaults that guard when that worker, and when that worker passes his room later on, he says, "I should have killed him." He is being physically intimidating and being aggressive once again. It's repetition of a behavior that's been going on for 10 years. He still has the same behavioral problems going back to when he was 5, 6, 7 years old, and they have not gotten better. They've gotten worse. They're behaviors that can probably be traced back to his trauma as a child, as well as to the learning disabilities that he has, but they're problems that have not been able to be addressed on their own so far. When we get to the actual homicide, when we get to the death of Aaron Holmstrom, it's really hard to talk about without starting with and without thinking about this shouldn't have happened. There's multiple reasons like that. One, as TP said on her statement, it was over an extremely dumb reason. Ashton was missing a chainsaw, one of 3 chainsaws that he had, and believed that Aaron must have took it. He didn't really have any reason other than Aaron is just there at the property and that's where the chainsaw disappeared. And as a result, Aaron wound up dying. In their search for premeditation, law enforcement went around talking to a lot of people who interacted with Aaron and Ashton and know them and interacted with them leading up to the incident, looking for, was Ashton telling people, "I'm going to fight Aaron about this"? Is he saying, "I'm going to hurt him"? Is he saying, "I'm going to kill him"? They found that Ashton was talking to people, that he was missing a chainsaw. He's mentioned that he believed Aaron took it, but none of them were under the impression this was going to happen. So it wasn't premeditation, and the situation itself, Aaron arriving late at night to get mail and to take a shower, where Ashton just happened to be there eating, belies any sort of belief that this was some sort of lie in wait kind of homicide. It wasn't a cold-blooded slaying. The other reason the shooting shouldn't have happened, and this is the big one, this is the most aggravating factor of the case, is because Ashton shouldn't have a gun. He was adjudicated delinquent of a felony. This court itself told him you cannot possess a firearm for life, and he did anyways. That adjudication was not that long ago. So a crime was committed before Aaron even arrived at the residence. A crime that, if not committed, the shooting couldn't have happened because he wouldn't have had a gun. If Ashton Heyer had been following the law that day, this homicide could not have occurred. That is the single most aggravating factor in this case. The reasoning for why we strip people of possessing firearms after being convicted or adjudicated delinquent of felonies is longstanding in the Western tradition, and it's because people who commit those things are higher risk. They have poorer judgment, they have poorer perception as to when to use lethal force, and that's why they need to have that right taken from them. They have a tendency to be more dangerous than people who are not felons, and Ashton is one of those people. Additionally, Ashton has specific professional psychological assessments that indicate further incapacities that render him even less likely to render good judgment with a firearm. His diagnoses related to aggression, intimidation, and flawed perception. So what happens next? Aaron arrives there, he drives into the residence. He's collecting mail. He's going to take a shower. Tina's there as well. According to the neighbors across the street who have no dog in the game, the most neutral witnesses there, they hear Aaron and Ashton yelling at each other at extremely loud volumes. You can hear them across the street inside your house. They were yelling. They heard Ashton yelling about a chainsaw. They heard Aaron yelling, threatening things at Ashton, both back and forth. They were yelling at each other about the chainsaw. Ashton essentially accusing Aaron of being a thief, and Aaron saying threatening things in turn. According to both Ashton Heyer and his girlfriend nearby who was there and saw the whole thing, Georgia Richards, both of them were talking tough until Aaron began saying physically threatening things to Ashton and began slowly walking towards Ashton. At one point, arming himself with a bat lying on the ground that belonged to Georgia Richards. TP, Aaron's girlfriend at the scene, reported she didn't see the incident happen, but heard it, and also at one point indicated she knew Aaron did arm himself with the bat, but she thought he was just going to give it to them. She said that Aaron's behavior was just boys being rowdy with each other. At this point, Ashton removed the rifle from his truck. It was a rifle that belonged to Mark Holmstrom, the victim's father, who did not know that Ashton had the weapon. And Ashton pointed it at Aaron, threatening him to back off. At some point, doing a warning shot that did not strike Aaron. At this point, Ashton claims that Aaron started to back off, started to go to Tina, but then somehow they started up the argument again, and he once again began approaching them. At one point, Ashton says that Aaron threw something at the truck, but believed that Aaron was still armed with the bat. Georgia said that Aaron threw the bat and was unarmed when he was shot. She said that she was screaming at Ashton to put the gun down, but he just saw red and wasn't listening. At that point, Ashton fired the rifle. The bullet struck Aaron Holmstrom in the chest, and it was the cause of death. It entered mid-chest, and it went front to back, slightly downward and to the right, penetrating the base of Aaron's heart, severing the coronary artery, entering the right lung, grazing one of his vertebrae in his back before stopping in a muscle in his back. Aaron succumbed to the wound extremely quickly, expiring at the scene while life-saving attempts were being attempted by first responders. Given the nature of the wound, shot in the heart, nothing could have been done. Ashton is the one who called law enforcement. When the first officer arrived on scene, Ashton told the officer it was self-defense. Ashton and Georgia both did interviews with law enforcement, where they gave extremely similar accounts of what happened. In his interview, Ashton both described the incident as self-defense and remarked that Aaron was being threatening, that he has known Aaron for a long time and believed that he's known Aaron to be physically aggressive in the past, and that's why he was threatened. But he also said he wasn't particularly scared. He said he didn't intend to hit Aaron. He said he was trying to do a second warning shot towards a structure behind Aaron, and that the bullet striking Aaron was an accident. Ashton and Georgia estimated the distance between Aaron and Ashton to be maybe 10 to 15 feet. Law enforcement measured the distance between the body and Ashton's position to be 40-some feet. The conditions were extremely dark. It was a wooded environment. Ashton was behind the open door of his truck, kind of like over the window, aiming the rifle, using it as a brace. Ashton said it was so dark he couldn't use the scope, so he eyeballed it. So with that summarized with the history of Ashton and with the summary of what we discovered when we investigated it, my position and the crux of, what's been argued by defense, the motions that we've been arguing with each other, was that my argument was that self-defense should not come into issue unless there's some evidence of it, and that require owning up to intentionally hitting Aaron Holmstrom, something Ashton did not do. I'm not going to spend a lot of time on that because this is sentencing, and that really has nothing to do with sentencing. Should self-defense have come into play, we'd once again be talking about issues Ashton has had in the past. Duty to retreat. It was dark. It was a wooded environment. Aaron was moving slowly towards him. He wasn't running. He wasn't closing the gap. He wasn't rushing him. He had a vehicle easily accessible. He was in the open door. His trailer was nearby. And excessive self-defense. The response to your brother walking towards you slowly, saying he's going to whoop you, is not to shoot him through the heart with a rifle. That's not the minimal amount of more force necessary to terminate that perceived unlawful interference with your person, especially when you're not legally allowed to own a gun to begin with. Ashton Heyer is 19, his brain is still developing, and that's a mitigating factor for sentencing. However, this constant trend of overreaction stretching back years unabated is an aggravating one. It's a pattern, it's an escalating pattern from substantial battery to the assaults, to the threats to the worker at JDC, to this, all in a really short period of time. And then it stretches back years further back to a child, where interventions by his mother were unsuccessful, interventions by Burnett County were unsuccessful, interventions by St. Croix County were unsuccessful. This also goes back to how I described the possession of the firearm itself being one of the most aggravating factors in the case. It's why it needs to be a max penalty of the negligent handling, because possessing it at all was negligence. What does Ashton's juvenile and JIP's record show? It shows he has 10 some years of history of impulsive violent behavior, punching holes in the walls, of attacking staff, getting physical with peers, physical intimidation and aggression. His own mother walks on eggshells in her own house when he's there because she's afraid of that. There's a reason Ashton was staying at Mark Holmstrom's property and not Katrina Hires. He is exactly the type of person who should be prohibited from possessing a firearm because firearms are so final, they're so lethal in what they do. Even possessing one changes the way you act. For normal law-abiding citizens who don't have the mental health conditions that Ashton Hire does. A person getting in an aggressive shouting match with someone that is about to come to blows might run away, or they might come to blows, and then they both come out worse for wear. But if someone has a gun, it changes how they do. They might stand ground, they might do something permanent. It brings to mind to me, the first thing I actually thought of when I thought of this case was the Odyssey, written by Homer, like 3,000 years ago. In that book, there's a point where Odysseus, the main character, is returning home to win back his wife, who's being pursued by a bunch of suitors who believe he's dead. They're at a hall and they're all pursuing, and he's angry about it. So he goes to the hall with his son, Telemachus, and his son says, "Where should we bring the weapons? Where should we hide the weapons?" And Odysseus says, "Don't bring any weapons, stow the weapons. If we come to blows, we bring dishonor on the feast and we might be injured, but bringing the weapons would change how we act and bring permanent consequences." He said, iron has power to draw a man to ruin. And that's exactly what happened here. Ashton Hire had iron he wasn't supposed to, and it changed his behavior. It changed the outcome of this situation where this could have maybe been two brothers coming to blows and then walking away from it. Instead, somebody's dead. That's the most frustrating part about the whole case for me, is that we're having a sentencing hearing right now for an individual for committing a crime that could only have been committed by him ignoring his last sentencing hearing with this court and what the court ordered at it. He's been out of JDC for only a few months when this happened, and he violated the sentencing order in the worst way imaginable. The reason we settled on negligent handling of a firearm causing death is because, as I've alluded to, the state simply didn't find the evidence it was seeking for premeditation, some sort of evidence of planning, of him expressing a desire to physically assault Aaron prior to this happening, the nature of Aaron arriving there late at night where Ashton just happened to be there. He wasn't lying in wait. He wasn't waiting for an opportunity to kill Aaron Holmstrom. It was purely a circumstance of two people getting hot-headed with each other and misperceiving each other's actions in the situation. It was a hot homicide. Reckless homicide, the difference between reckless and negligent. Reckless is you cause someone's death by creating an unreasonable risk of death or great bodily harm and you're aware of it. Negligent homicides, you create a risk of death or great bodily harm and it's silent whether you're aware of it or not. The state is immensely cognizant of Ashton's past diagnoses, the ADHD, the mental retardation. He's been found not competent to stand trial previously before in a delinquency case. The way he thinks is different. He's been on IEPs his whole life. He has profound learning issues. He has profound perception issues. So when the state has to prove he actually perceived the risk, not objective reasonable person standard, but subjectively was aware of it, it becomes harder there because Ashton Hire, I can't just put myself in his shoes and do it because he thinks differently than me. So that's how we wound up on the negligent homicide. And that's how we wound up on being a fully aggravated negligent homicide because of the lack of that risk calculation element because of his personal characteristics. As to the self-defense assertion, I know in the past at hearings, I think either Ashton or his attorneys have complained that I'm unfair in my characterization of, the circumstances and the facts. It's one-sided. I mostly highlighted the aspects unfavorable to Ashton because that's my job. adversary counsel. In fairness and giving the court a complete picture, I am going to highlight some of the aspects that cut in his favor on that. The most favorable aspect was the fact that there definitely were violent convictions in Mr. Holmstrom's past. That was the basis of the McMorris motion and the physical aggression at the scene. All of the witnesses were going to say that Aaron was being physically aggressive. For a jury, for me, for anyone thinking about the situation, you know, you put yourself in Ashton's shoes and it's easy to think, hey, why would you think Aaron's going to assault you? He's your brother. He's not a stranger. It's unreasonable for you to believe he's going to hurt you in some manner that would justify lethal force. But on the other hand, it's really hard also to put yourself in Aaron Holmstrom's shoes and think, you also know your brother. You know Ashton has these issues. There's no way you don't. His diminished capacity, his poor judgment. There's no way you didn't see him do that warning shot as he's telling you not to approach. And then why is he still approaching? Because, as TP said, he was kind of daring Ashton. He was putting Ashton on the spot with that situation. I don't know how a jury would have dealt with that. The final factor that is hard to grasp with is when they did the autopsy, they also took Aaron Holmstrom's blood. They measured it. There was an extremely large amount of methamphetamine in his system, about 7 to 15 times the typical therapeutic range of the substance. And there's no way to keep that out for jury. I don't know how jury would have used that. Neither Ashton nor Georgia said anything like they believed he was under the influence of drugs, but we know methamphetamine affects the way people act and perceive things and their physical demeanor. They get twitchy, they move in certain ways. There's an uncanny valleyness of it. I don't know what a jury would have done with that fact. So you can look at it all and say Ashton shouldn't have been intimidated by Aaron because of the brothers, not strangers, shouldn't have chosen to use lethal force. You can look at it from the other way and come to different conclusions. It's really hard to put yourself in either situation and view the actions of either of them as reasonable in that situation, because Aaron was being physically intimidating in the face of a warning shot. It's hard to imagine what more Ashton could have done in that situation where he has the rifle, he's done the warning shot, and his brother's still approaching him after threatening violence. Whether, that's when it comes into the duty to retreat, fleeing into the woods, or jumping in the car, or just throwing away the gun and determining what the appropriate level of response should have been in that situation. What I'm getting at, judges, this is a situation where two people, brothers, behaved in really similar ways and woefully misjudged each other in the situation. The joint recommendation therefore represents a couple things. It represents an acknowledgement by the state that we couldn't find the evidence of premeditation to conclusively prove an intentional homicide. A Columbo murder, as I called it in the beginning, where someone deliberately plans and executes a homicide. It also represents an agreement that as a negligent use of a firearm, as Ashton himself described it, didn't intend to shoot him, intended to do a warning shot, it missed and struck him, that this is fully aggravated. It's fully aggravated because that's just poor judgment, shooting in someone's direction for a warning shot. It's aggravated because he wasn't supposed to have a firearm. He's prohibited. It's aggravated because of the situation. We know that for a decade now, Ashton has been through numerous behavioral and psychological interventions that have been to no avail. They've been outside, they've been through the 180 program, they've been to no avail. So treatment is necessary in a confined setting. The level of services Ashton's already been through is of the highest I've ever seen. It's aggravated as well because the escalating pattern of impulsive violent action disproportionate to the impetuses that cause it. It's aggravated because he never should have had the gun to begin with. This joint agreement also benefits Ashton. My intent at trial, and I think I wrote about it in one of my motions, was to give the jury options on all these levels of mens rea and let them decide it themselves. The jury could have found he was aware of the risk, could have found he was acting in indifference to death or great bodily harm or human life. The jury could have found it was intentional. How a jury determines mens rea is really wide open and up to them, because it's all about the circumstances and it's guesswork based upon facts and circumstantial evidence. There's a possibility that if Ashton went to trial, he could have gotten a mandatory life sentence. He could have been convicted of a higher homicide that could have had a longer penalty. On the other hand, while 7 years doesn't seem like much to you or me, Judge, to a 19-year-old, that's more than a third of the life he's lived so far. Relatively speaking, it's a significant penalty. I'm certain it achieves the objective of deterrence. And I'm sure it achieves punishment objectives. I think the long period of 10 years extended supervision achieves objectives of protecting the community if he doesn't curb the behaviors, because that's what a 17-year bifurcated sentence means. It means that 10 years is available for him to go back to prison if he continues down this path. When we have a homicide case, a case involving a death, we're still sentencing a defendant based upon the McCleary-Gallion factors. Same as non-death, same as non-violent cases. We're not assessing a value to a life that has been lost with actuarial tables. We're not matching eye for an eye in Hammurabi style. We're looking at a lot more. We're looking at the totality of the circumstances. We're looking at protecting the public. We're looking at rehabilitative needs of the defendant. We're looking at impact on the victims. With Ashton's personal psychological history, the cause of the psychology, the escalating behaviors over time, his age, a significant prison sentence, though harsh, is necessary. The 7 years initial confinement is the right amount of prison for this offender with these circumstances. The 7 years is the necessary and it's the minimal amount of incarceration that will not unduly depreciate the seriousness of the offense. We know that Ashton strongly disliked the time at JDC because of what he said when he came into court and zoomed into court during that time from his letter to the court. We know he strongly has disliked jail here. So we know that incarceration, the restriction of freedom, is effective in so far as it's a negative reinforcement in terms of behavioral psychology. It's an effective way to punish him because he dislikes them. It's a negative reinforcement. Treatment in the community for the past 10 some years has been ineffective. We can't do it. It's not safe. It doesn't work. Furthermore, the sentence has to have a generally deterrent effect on people to not possess firearms if you're a felon. That has to be hammered because the risk it causes and to discourage people from taking matters into their own hands. This is a case where a person has died. Aaron Holmstrom has died. He died because Ashton Heyer killed him. He never should have had that gun. He's the last person in the world who should have had a gun. Regardless of what Aaron Holmstrom was doing or saying at the time of his death, there were numerous options available to Ashton Heyer that could have resulted in both of them today. Once again, Ashton's impulsive violence, poor judgment, and poor perception of circumstances and other people's actions and words has had a catastrophic consequence. It's caused pain, it's caused suffering, it's caused death. This time it's not his mom, it's not a social worker, it's his brother. It's his brother's girlfriend. It's his brother's father. World has ended for Aaron Holmstrom. And I'm sure it feels like it's ended for the other people close to him. This sentence accomplishes punishment. It's for punishment. It's for deterrence. It's for appreciating that loss that these people have felt. And it's a crime that requires a prison sentence today, and a lengthy prison sentence, as I've outlined. Because Mark Holmstrom will never be able to go fishing with Aaron again or talk with him about his day, because Tina will never be able to talk about high school and see what would have happened if they continued together. There's no way to really make up for that loss. It's impossible. And it's something we need to impress in people when they cause that loss. Why? Even in circumstances where maybe there is something a little bit to self-defense or the mens rea or the circumstances, we still need to do harsh prison sentences, because it's necessary not to appreciate that loss. Thank you.
Thank you, Mr. Schmidt. Ms. Chevalier?
Yes, Your Honor, thank you. The state has eloquently addressed both sides of the argument, so I will not dwell on the areas and the aspects that he has already covered. But as he has mentioned, and as has come up in my sentencing memo and the attached letters, Mr. Heyer has suffered multiple traumas in his very young life. He's only 19 now. When this occurred, he was 18 years old. His mental health needs went virtually unaddressed. And I say that because it's complicated by living in a rural area. First, you take his age, you would need to have someone who specializes in child psychology to know how to adequately address a child. That did not happen here. In addition, he struggled in school. And being in a rural area, the schools here could not adequately address his educational needs. That was evident when he transferred to a different school for a short period of time, where the school learned to adequately address his needs and find different alternatives to teach him. And he was engaged and doing well in school. Unfortunately, he had to move and was right back where he started again. Despite all of these challenges, he's always stayed optimistic. He's worked hard. He's super helpful. He's been always lending a helping hand to his neighbors, helping with lawn mowing and wood cutting and show snuffling, whatever was needed. He always helps family and friends. He's also a very talented mechanic and a creative inventor. Now, he does have juvenile adjudications and was told by the court that he could not possess a firearm. However, Ashton did not fully understand that that was a lifetime prohibition. The court may have instructed him as such, but he was not sure. He called his social worker, went and met with his social worker at the completion of his supervision, and asked the social worker whether his rights were fully restored now that he completed his supervision. He didn't specifically ask about firearms, and the social worker did not specifically address it. But to his mind, when his social worker said that his rights were now fully restored, that meant he could possess a firearm. He understands now that he's wrong. He probably should have done some further checking before taking that very harsh step that he's facing consequences for now. Now, there's some other aspects that I think need to be addressed about this incident. Ashton and Aaron are not brothers, they are stepbrothers. And for most of Ashton's life, when he was growing up, when his mother was involved with Mark Holstrom, Aaron was in prison. So he didn't spend his childhood growing up with Aaron. Aaron got out of prison sometime later. Now, Mark Holmstrom and Ashton had a very close relationship. Mark taught him his passion for mechanics and working on cars. He would take him camping and fishing and doing all kinds of fatherly type things. Mark was the only father figure that he had for a certain period of time in his life. And they did have a very close relationship. Now, prior to this incident occurring, Ashton had discovered that a chainsaw was missing. Aaron was banned from the property by his father. He was not to be living at that property. But Aaron knew, or Ashton knew, that Aaron would sometimes show up at the house when his father wasn't home so that he could shower, do whatever, get something to eat. And so he noticed that his chainsaw was missing and asked if Aaron had taken it for any reason. And Aaron said no. And Ashton went around the neighborhood asking if anyone knew where the chainsaw went. So on the night in question, he and Georgia had gone out during the day. They were cutting firewood in the woods. And Mark Holmstrom had given Ashton the rifle earlier to take with him to use as defense in case they were approached by some large animal that they were afraid of. They took it along for only that purpose. They worked all day in the woods. They came out, they had dinner, they stopped and got ice cream. On their way home, they pull up to the entrance to their property. Now, this driveway is very long. It goes very far back. And the property, if you saw the pictures of it, it would look like a dump to you. There's garbage littered all throughout that property. When he pulls up to the entrance, Aaron was there at the entrance. And Aaron starts accusing Ashton of calling him a liar and going on and on about the chainsaw. And Ashton didn't really care. And he was used to Aaron, and he was used to him being loud and belligerent and didn't think anything of it. And he and Georgia proceeded to the back of the property, driving their truck while Aaron was walking down the driveway. Georgia and Ashton get out of their truck, and Aaron continues to walk toward them, screaming and yelling the entire time at Ashton. He stops along his path and picks up a bat. And he begins to threaten Ashton, saying he's going to beat his head in with the bat. At first, Ashton didn't really believe anything about it, but he could tell there was something different about him, the way he was approaching him, the way he was speaking to him. He did perceive a threat. So he went back into his vehicle and he got the rifle out, and he continually asked Aaron to stop, to turn around, to leave him alone, to just leave. And Aaron wouldn't. He still kept coming. Ashton fired the rifle into the air as a warning shot to try and get him to stop. At that point, it seemed to have set Aaron off. And from what Ashton saw, it appeared to him that Aaron was now charging at him with the bat. And that's when he shot another time. He wasn't intending to hit Aaron, but he wanted to stop him because Ashton was actually afraid. He was not only afraid for himself, but he was afraid for Georgia. He had never seen Aaron so threatening and violent in his life, and he was afraid, and he shot. What Ashton didn't know at that time, as the state has mentioned, is that Aaron had consumed a large quantity of methamphetamine. According to the medical examiner's report, the amount was so large that aggressive and violent behavior is a likely result. Now, Ashton, I believe, was aware at some point that Aaron was high on meth, because that was one of the first questions he asked us when we met, was whether or not we had gotten the toxicology report, because he believed that Aaron was on meth that night. And Aaron has been known, we did our own investigation and found that Aaron is known to be a meth addict, to be walking around with knives and machetes and baseball bats, threatening everyone in the neighborhood and basically being a menace. Ashton was also aware of a lot of that aggressive behavior. However, he had not seen it turn toward him. Now, Ashton is going to have to live with the knowledge that he took Aaron's life for the rest of his life. While he's been in jail, he's been plagued with nightmares, and he's also been plagued with the what ifs. What if he didn't pull into the driveway that night? What if he kept driving? What if he got back in the truck and left? What if he and Georgia arrived later that night? What if they had come home earlier and didn't run into him? He understands the tremendous impact that his actions had on Aaron's family and friends, especially Aaron's father, Mark. As mentioned, Mark Holmstrom was a father to Ashton for a very long time. Mark taught Ashton so many useful skills. And he understands that he has lost that father-son relationship that he cherished with Mark. Now, from the beginning, Ashton has accepted responsibility for his actions that night. He immediately called 911. He told the 911 operator that he shot Aaron. He admitted to shooting Aaron as soon as the police arrived on scene. And he has believed from the very start that he should face consequences for the act of taking another life. Even though, based on the circumstances that existed on that night, his actions were justifiable. He did have a self-defense claim in this case. Self-defense can be used regardless of intent. Self-defense is available for any crime, regardless of whether it's reckless, negligent, intentional. But he wanted to accept responsibility and accountability for his actions, which is why he has decided to enter into this plea agreement. It also should be noted that he's been in custody now for approximately a year. And during that time, he's had no incidents of violence, of bad behavior, or anything else in the jail. He's been doing very well in the jail. And in fact, some of the jailers have commented about how he has walked away from situations where other inmates are trying to antagonize him. He's very young. He still has a lot of growing to do. Hopefully, his needs can be met. He understands that he may be able to get some services while in prison. He also knows that when he gets out, his biological father lives near Minneapolis, has a job waiting for him at a local union where he can work. He'd be in an area where he could get the services he needs because it's a highly populated area with a lot of services available. There aren't as many services available in rural Wisconsin. So based on all of the facts and circumstances surrounding this incident, we would ask the court to adopt a joint recommendation. Thank you, Your Honor.
Thank you. Mr. Heyer, I'm now going to turn to you. This is going to be your opportunity to provide any statement that you wish to the court as it relates to this matter and to yourself, and anything else that you would like me to consider or know before I render a decision, render a sentence in this case. You can also use this time to clarify anything that you believe may have been misstated by either your attorney or by the state. Mr. Heyer, do you wish to make a statement today?
Yes.
All right. Yes, thank you, Ms. Chevalier.
I just want to state that that chainsaw had nothing to do with it. I borrowed that chainsaw from a man who bought it at a garage sale for $45. In fact, I had more than one chainsaw. I wasn't even angry about the chainsaw. I wasn't angry at all. I honestly have nothing further to say. There's nothing I can say that can make anybody feel better. There's nothing I can do. That's it. I got nothing.
You wish to use this opportunity to express any remorse you may be feeling about the situation? I guess if you have any.
Yeah. I do. I blame myself every day. I can't imagine how it was for Tina, you know? I watched her hold him in her arms as he died. All she had to say to him was, I love you. I can't imagine how it is for Mark when he pulls home into his driveway every day. All he thinks about is his son laying there dead in the driveway. I can't imagine what it's like every day. And the amount of hurt. I really can't. I just, yeah. I was scared. It only takes one blow to the brain I mean, it doesn't have to kill you, but it cripple you. You know, that's it. I, believe me, I wish I would have done something different. But when you're scared and cornered, you panic and you react in a way you normally wouldn't do. I am sorry for that.
Thank you, Mr. Heyer. First, I want to say both the state as well as the defense made very thorough arguments and both eloquently said things about this case, about the victim, about the situation, and about Mr. Heyer. Quite honestly, this is probably, well, because of the seriousness of this offense, both sides did present probably the best arguments I've heard in a very, very long time as it relates to cases in front of me. This court has known Mr. Heyer through many different situations for a very long time. I believe since I first took the bench back in 2017. I have seen the struggles that his mother has went through. I've seen the struggles that Mr. Heyer himself has went through. I've seen the struggles that the school has went through, and I've seen the struggles that the victims of Mr. Heyer have went through. I have seen the effects of the trauma that Mr. Heyer has so unfortunately had to go through from his early years of life. I have seen Mr. Heyer attempting to go through therapeutic programs and receive counseling and services. I've seen Mr. Heyer refuse those services. I have gotten to know Mr. Heyer a whole lot more through this case and through the motions that have been filed and the statements made by both sides. But as it relates to Mr. Heyer and his learning disabilities and his reactive type disorders and his flawed perception of situations or dangers and threats. Plain and simply, this should never have happened. It should never have gotten to a situation where a person's life has been taken, where somebody is now dead. Regardless of Mr. Holmstrom, Aaron, regardless of his history, of his past, of his at the time present behaviors or illegal substance use or abuse, this never should have happened. It never should have reached the escalation that it did. It never should have got to the point where a gun was taken out, that a gun was used to try and de-escalate a situation. The state eloquently, very well stated that Mr. Heyer never should have been in a situation with a firearm because Mr. Heyer, his firearms privileges have been permanently removed from his juvenile conviction. In sentencing, a court has to look at multiple factors, and again, those were stated very clearly in the arguments that I have to look at the seriousness of the offense or the offenses in this case. There is no doubt that this is one of the most serious types of cases. I also have to look at Mr. Heyer, his character, his rehabilitative prospects. That's part of sentencing as well as a need to protect the public. If we look at the charges that have been laid out or charged by the state in this matter, Mr. Heyer could have, if convicted, been incarcerated for life. Even if the intentional homicide charge was taken off the table, Mr. Heyer could have been incarcerated if found guilty on the remaining charges for over 80 years, essentially life. By entering into the plea deal, most of that was removed. Most of that came off of the sentencing plate, and Mr. Heyer became only vulnerable to a potential 20 years max, 10 years for each count if the court were to do a consecutive sentence. That's a significant benefit of the bargain. I'm not going to rehash the arguments by either side or what the state argued in its argument and recommendation to the court as to whether or not the jury could find or would find that this was an intentional homicide versus a reckless homicide versus a homicide by negligent handling of a dangerous weapon. And the court will not go into whether or not there could be a perfect self-defense argument in this case or an imperfect self-defense argument in this case. Again, that would be for a jury to determine and to decide. The parties have reached an agreement for a global recommendation to the court of 5 years of initial confinement, 5 years of extended supervision for the homicide by negligent handling of a dangerous weapon, and 2 years of initial confinement and 5 years of extended supervision for the possession of firearm by an adjudicated delinquent of a felony. And the recommendation is to have it be consecutive. The court has to also look at other certain factors in this case, as well as other cases, as Mr. Schmidt stated, the totality of the circumstances, as well as looking at the effect on the victims, any of the real rehabilitative needs of the defendant, either in an institutional setting or outside in a community, if that is even possible. The court also has to look at undesirable behavior patterns of the defendant, culpability, the age, the education, the history. The court also has to look at deterrence, not only deterrence to Mr. Heyer himself, but deterrence to others who could be in the same or similar circumstance. I have considered the arguments by both sides. I've read the sentencing memorandum. I've heard the victims' statements and impacts throughout the duration of this case. I have also read the character references or letters written on behalf of and for Mr. Heyer. From the very beginning, Mr. Heyer has admitted his guilt, as in the shooting and killing of Aaron Holmstrom. The level of the guilt has been what has been argued in front of this court. both sides, as well as this court, fully understand that this is not a probation case. This is nowhere near could this ever be a probation case, because anything on probation would unduly depreciate the seriousness of what occurred and the loss of life and the death of a man. And in this situation and circumstance, he was an innocent man who did not deserve to lose his life. So confinement is necessary. The court has to determine whether or not maximum possible penalty of 10 years for each count is necessary, or whether or not there should be any differing from that or accepting the recommendation by both sides. For the court, this is not an emotional process. This is a rational process, and I have to look at everything as the law applies to the facts, or the facts apply to the law. The court, as well as everyone in here, no one has the ability or the power to undo what happened, even though probably everybody in this room and hearing this right now wishes that it could be undone. And I believe Mr. Heyer when he says he wishes he could go back and change the circumstance and stop what had occurred. As Mr. Schmidt argued, the mere fact that Mr. Heyer had the firearm in the first place was the first violation of the law and the first escalation of the incident. Because when a firearm is involved, and that was a very good analogy with the Odyssey, an incorrect perception of the situation and an unnecessary escalation by the use of a firearm occurs. This was definitely a hot-blooded killing. Although I believe that there has been situations involving Mr. Heyer as well as with Aaron throughout their history, and I believe in one of the arguments or one of the briefs or one of the statements made in one of the hearings, Mr. Holmstrom, Aaron, may have constantly picked on or was aggressive to or mean to Mr. Heyer as he was growing up. That is still absolutely no excuse, no reason to escalate the situation with a firearm. The court can't change the outcome of what occurred. Can't make things better with a sentence, either a maximum possible penalty or anything other than that. What the court can do is attempt to apply the legal principles to the situation and properly exercise discretion under the law. The court cannot excuse or not take into account Mr. Heyer's juvenile past, especially the incident that occurred prior to the killing of Mr. Holmstrom, because that was an extremely severe case in which Mr. Heyer and another co-defendant, co-juvenile defendant, severely and substantially injured another human being, and also attempted to burn down that person's dwelling or residence. Although age, learning disabilities, trauma, those things are mitigating factors or things that the court looks at in mitigating a sentence, the escalation and continued escalation of behaviors is aggravating. Mr. Heyer has some very good qualities. And that was stated by both sides, and in particular by defense in the memorandum. He can be kind, and he can be generous, and he can be giving. And although he does have learning disabilities, either to the extent of what the state recited or to any other extent, he is a very smart young man. From the time the court has gotten to know Mr. Heyer through the cases, the court has been in tune to his abilities, his great abilities to be able to use his hands and build things and fix things and make things work when perhaps others are not able to. Two lives have been affected today, the victim and Mr. Heyer specifically. Although the death of Mr. Holmstrom has impacted a community and an entire family and others. Mr. Holmstrom lost his life. Mr. Heyer is going to lose a significant large portion of his life. But that is his own doing and by his own hands. The court does see Mr. Heyer and his efforts and what he has continued to try to do with getting his high school education while he was in JDC, by towards the end opening up to the treatment, opening up to the counseling, and doing those things to try and help the trauma that he has experienced his entire life. Unfortunately, up until September 1st, 2023, that was not enough. I understand where the arguments are that the court has to focus on protecting the community, protecting the public, and that is justifiably so, because it appears that without treatment, without having intense treatment, Mr. Heyer's behaviors continue to escalate. And now a death has occurred, a loss of a life, a loss of a family member, a loss of a son, a loss of a fiance, and no one can bring him back. I have no doubt that Mr. Heyer is suffering from this every day. I have no doubt that he is experiencing nightmares, perhaps nightly, because of this situation, but so are others. I do believe his remorse is true. I do believe that he truly experiences these feelings of remorse and wishes that he could change the situation. What Mr. Heyer is in need of, and the community is in need of with Mr. Heyer, is that intense mental health treatment and counseling, especially focused upon trauma. And if this doesn't occur, unfortunately, Mr. Heyer could be spending more time incarcerated, and the community could be at risk even more once he is released. Mr. Heyer doesn't understand or does not fully comprehend the seriousness of his actions and reacts instead of taking time to respond. And the court has to look at that and protecting the community. As it relates to count 7, homicide by negligent handling of a dangerous weapon, the court is sentencing Mr. Heyer to the maximum possible penalty of 5 years of incarceration, 5 years of extended supervision. As it relates to count 2, possession of a firearm by an adjudicated delinquent of a felony, the court will also follow the recommendation of 2 years of initial confinement, 5 years of extended supervision, and that will be consecutive to count 7. Anything less would unduly depreciate the seriousness of the offense. And the court did not sentence a maximum possible penalty because there will be that additional 10 years of extended supervision, as well as the fact that the court is not making Mr. Heyer eligible for the challenge incarceration program and not making him eligible for the substance abuse program. This will be an entire sentence that will be sat and served. And that is because of the seriousness of the offense and the fact that a life was lost. So there will be 10 years following his release where he could potentially sit again, additional time incarcerated in prison if he is unable to change his ways and if he's unable to get the trauma and mental health services that he so desperately needs. Conditions of extended supervision: absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia, no alcohol, no going into any establishments that have the primary purpose for the sale or the service of alcohol, no casinos. Court will also order gainful employment. The court will order a program while incarcerated, such as thinking for a change or breaking barriers. The court will order a mental health evaluation, and he must follow all recommendations until full completion. The court will order a trauma-informed counseling and follow all recommendations. No use or possession of a firearm for life, for absolute life. No voting in any election until civil rights are restored. $518 in fines and fees per count. Failing to pay means the court will enter a civil judgment against him and he could sit up to 6 months in jail. That will be paid to Department of Corrections as a condition of extended supervision. No contact with victims or residences. Mr. Schmidt, any other conditions that I am overlooking?
No contact with the victims.
Just said that, literally.
Oh, sorry, I was thinking their initials in my head.
Ms. Chevalier,
No, Your Honor.
how many days jail credit?
Your Honor, I did not bring that calculation with me, but that was from September 1st of 23 through today.
I believe I can probably look at the roster and see how many days he's been in custody. The roster doesn't have the dates on this roster for some reason. Hopefully, jail would be able to update that for future to include that for cases such as this. I will give 5 days to update the court so the court can amend the judgment of conviction with the number of days incarcerated for jail credit. The court is ordering DNA. The jail will make sure that DNA is received. This is not one that can be expunged. Mr. Schmidt, what else is the court missing?
Nothing from me.
Ms. Chevalier?
Nothing, Your Honor.
All right. There's nothing further, then we are adjourned.